Today's episode is supported by Red Bar Law, the go-to law firm for expert, efficient and fast legal assistance, all at a fixed cost. Go to our website at redbarlaw.com. Hello and welcome to our podcast at Get Legally Speaking. Our legal conversation today will be about prenuptial agreements. I am joined by Barrister Nicola Frost from 3 Paper Buildings Chambers in London. Nicola is a specialist in family law and she is described as being feisty but fair with a great attention to detail. Nicola is well rehearsed at dealing with sensitive family matters and she also undertakes court of protection cases. Nicola, thank you so much for joining me.
Thank you, Hatti.
Right, prenuptial agreements. This is a really interesting topic. I think that most people in their sort of younger adult life, if I may say so, are aware of or have heard of them, etc. And, you know, whilst no one enters into a marriage expecting to separate, the Office of National Statistics reported that there were over 107,000 divorces in 2019 alone. That's 42% of marriages. I mean, it's a high number, isn't it, Nicola? It's not, you know, to be sniffed at.
Yes, it's a very high number, and unfortunately, but that is where we are with the world at the moment, unfortunately. Not every relationship works out.
Absolutely. No, I get it. So let's start by telling our listeners what is a prenuptial agreement, or prenups as they are also known as, please.
Okay, so a prenuptial agreement is simply an agreement that is made between 2 parties to a marriage. A prenup is one that's made before the marriage ceremony, and a postnup is one that is made within the marriage, and commonly they are called nuptial agreements.
Well, that's interesting, because I have to say I hadn't heard of postnuptial agreements before. So whilst you're married, if you want to try and protect an asset, let's say, because it would be an asset, I assume that people are trying to protect from a potential divorce in your marriage, you can make a post-nuptial agreement.
Yes, you can. Yes. So often you might find that a couple have made a prenuptial agreement and then they post-marriage make a post-nuptial agreement. Maybe there's been a change of circumstances that's changed the basis of their prenup, or given the passage of time they want to make it more current.
I see. Maybe an addition of an asset, or assets been disposed. But so can you only make a post-nuptial agreement if you've got a prenuptial agreement then?
No, you can make a post-nup if you haven't got a prenup as well.
That's interesting.
Yes, so it might be sometimes people want to protect inheritance or something like that. Let's talk about somebody who has a prenup. They've had a prenup before marriage. There may be some circumstances around that prenup that make it, you're not sure that it is a firm and an agreement that will be upheld, because perhaps you hadn't given enough time before the marriage to sign the prenup. So it might make it a little bit risky, as in the court might not want to uphold it. So you might enter a postnup after the marriage. So that's one reason.
So it's not just necessarily the fact that an asset may have been disposed of, or you may have acquired another asset, which you're both in agreement that should be, protected in a potential divorce. It could be the fact that you've made this prenuptial agreement, but as you say, it's got potential grounds of weakness on the basis that the other side, so the person that was asked to sign it and agree to it, didn't have enough time to seek advice or didn't actually seek legal advice properly, and there's other elements there that could make it a bit weak should it have to be exercised. So they are also reasons to do a postnup.
Yes, it might be that somebody has entered into a couple have entered into a prenuptial agreement without proper legal advice, or without fully understanding the implications of the agreement or what will make it a strong agreement. And they then subsequently have advice and they think, actually, I think we want to firm this up in a postnuptial agreement, for example. There is also the passage of time, because the further away from a prenuptial agreement or any postnuptial agreement you get, the bigger the change in circumstances that are likely, and the less relevant that agreement becomes.
Yes.
If you imagine, often in a prenuptial agreement, there ought to be a review clause, and that tends to be at the birth of any children, for example. People's needs and change at that time, or if one or other person suddenly isn't able to work, for example, if their work goes away, their income goes away, their assets might have changed significantly. There are, if I'm drafting a prenup, I certainly include in there a review clause, and in any event, you should probably look at it and check it again every 5 years about.
Yes. No, you're absolutely right. I mean, changes of circumstances happen sometimes overnight, sometimes gradually. And we're so caught up in life and every day, aren't we, that it's very easy to sort of forget about the prenup that was put together. And I guess also it's the quality of the advice that you've taken at the time that you've drawn your prenup. Because if you're not given this level of advice, you've gone to, for example, a high street solicitor to get a prenup done, and you're not told, look, the review clause is something that's key, or you should think about looking at what you agreed to prior to the marriage in your prenup and what your position is 5 years into it, say, or 10 years into it, then most people won't. They'll just think, I've got one, that's it, I'm safe. Everything that I've put in there is going to be safe from a divorce, and you crack on. But are prenups only for the rich and famous, Nicola? Because I have to say, I read this only this morning and I kind of smiled. The royal family, for example, do not have prenuptial agreements. And one of the most Googled things that I saw that I thought that's quite fascinating is, did Meghan Markle sign a prenup? And I thought, wow, look at we're all so busy with asking those types of questions on Google. So are they only for people with lots of assets or, big things to protect? Or say you've gone into a marriage and it's not uncommon that you had a flat, you had a house that you were living in. You met your partner whilst you had that home that you've been living in, that you bought yourself, or with the help of your parents, for example, or with an inheritance, and you want to protect that one property, that one asset, and it still might be mortgaged up. It may not be a mortgage-free multi-million-pound home. It could be a house or a flat that's £300,000 or £400,000 that you put your own money into and you bought, and you just want to protect that. What's your thoughts on that?
Well, certainly they're not just for the rich and famous. Prenups are very common these days for people entering marriages. It may be that it's a second marriage and there are children from the first marriage that the one or other party wants to look after and make sure that they're provided for, and they want to talk about their own inheritance planning. So Hatti, as you know, if you're divorcing, the starting point of any divorce is equality, 50-50 across the board. And then both parties put forward arguments either way as to why the equality ought to be displaced.
Yes.
And there's an argument about that.
Yeah, so why is that one party might get 60% and the other party might get 40 or 70-30? Yeah. And then the prenup comes out.
And then the prenup. If you've got a prenup and you've entered into it freely, you've had the benefit of legal advice, and the agreement is fair, it should be upheld. And if you're, for example, going into a second marriage, you want to protect your money for your children from your first marriage, you want to ring fence those non-matrimonial assets, and that is key, Hatti. They must be non-matrimonial assets, i.e. the property that you're bringing to the marriage, not your joint
I have
property.
Got some thoughts on that I'll lay out in a minute. But yes, I totally get it.
But it might be that it's a second marriage. It might be that both parties are bringing assets to the marriage because it's a second marriage. It might be that you've got an inheritance that you want to protect. Now, just on the inheritance point, if you are getting divorced, generally, and the courts say that the source of the asset is very important in any divorce. You could have inherited a sum of money, and you might have treated it separately all the way through the marriage. And in general, the court will only invade that as much as is necessary to meet the parties' needs. But there will still be an argument about it. Whereas if you've got a prenup that says, I want to ring fence this amount of money because it's inherited, I want to ring fence my inheritance, then you've got the prenup, everybody knows where they stand, you're limiting the litigation at the end of a marriage.
Yes, in the finances, in the finances of a divorce, your basic, if you've got that agreement that everybody, as you say, was clear upon, they took advice on it, and they signed it unhappily or happily, then it leaves less arguments to bring to the table about the assets. And I think you made a really good point there in saying it doesn't necessarily have to be the case that one party is trying to ring fence their asset or assets in a prenup. It could be that both parties want to ring fence. I mean, it's not uncommon that people get married twice, sometimes three times, and you could be in your 40s or 50s by that stage, and you could have an asset or assets, and it's likely that both parties could have something of value that wasn't brought into the marriage as during the marriage and was brought into the marriage prior. So I think that's very important. But I mean, isn't it very just unromantic to have a prenuptial agreement? And a statistic that I read on that sort of made me raise my eyebrows, and it's that it's been reported that 1/5 of couples who seek advice on prenuptial agreements break off their engagement. And I just thought, that's another high number. I do love statistics, and I thought, it doesn't sit well. I actually had a friend who is still a friend who asked for a prenuptial agreement, and her fiance at the time said fine, no problem, but they didn't get married for other reasons. But then I know somebody else very well who said, I've asked for a prenuptial agreement, the relationship was going swimmingly well, and she said, sorry, stuff you, I'm not interested. If that's the way you feel about me and you think that we're going to break up and all of these things came out, I'm not proceeding with marrying you.
Yes, well, it is a highly emotive subject. I know that people do view them as unromantic. However, I think that really they ought to be viewed alongside wedding planning, alongside wills, and even wedding cake, Hatti. They're just something ought to be.
Oh, do you like the colours of that wedding cake, darling? Yes, and here's our prenup, by the way.
They're just something that ought to be considered at the beginning of a marriage, because what it does, Hatti, nobody, I'm sure, well, there might be some people, but I'm pretty sure that nobody creates a prenup, enters into a marriage intending to get divorced. That isn't the intention of it. What you're doing is you're just planning just in case. And actually, the parties are saying, we're setting out our intentions. This is what we intend to happen with our finances. And they're treating them separately. They're treating them separately within the marriage as well. It's not just this is what's going to happen on divorce. It's giving them a degree of certainty if they do
in the unlikely event. We'd like to say unlikely event.
In the unlikely event of a separation and a breakdown of marriage. I have used the word certainty, Hatti. I must be very careful. These are not agreements that are automatically upheld.
Yes. And I've got a few... I completely get it. It's just assisting. A prenup will assist in trying to eliminate the bigger argument on finances upon a divorce. It doesn't guarantee it. Absolutely doesn't. And I'm just coming on to mention that because, will a prenup automatically be upheld in court? Is it legally binding? Following a precedent set in 2010 on a groundbreaking case of Radmacher versus Granatino, prenuptial agreements are now afforded heavy evidential weight within the UK family courts, unless considered to be unfair. So unless considered to be unfair, wow, that opens up a whole new can of worms, because you mentioned that the court needs to make sure that the needs of the parties are met. So whilst, and when we talk about marital assets or non-marital assets being assets that an individual had prior to the marriage, that they brought into the relationship and brought into the marriage, well, I have seen more often than not non-marital assets coming into the pot and into part of the divorce, so that each party's needs can be met equally. For example, housing, it's very common. And I gave the example of if you own a flat or a house before you met your partner, before you married, and then you bought a house together as a married couple, etc. And when you come to the divorce and there's children, well, everybody needs somewhere to live. It's not uncommon that a court would say, right, well, the wife can have the house if it's a reasonably sized house with or more often than not, with the two children who are under dependent children, and you can go and have the flat that was yours prior to the marriage, and that's an equal division of where everybody's going to live. So they are, I think it's fair to say, Rachel, upheld now and taken it's not more seriously, is it? It's they've got more weight than they used to have. Right.
They absolutely have. There was the Supreme Court case of Radmacher and Granantino, which you've referred to. That was over 10 years ago. After a lengthy litigation, there was a prenup in that case, a very simple one. In actual fact, but it was drafted in Germany, and it was the separation of property regime. They covered the assets in that case of the wife, and in fact, talking about the unromantic position, her argument in court was saying, yes, I'm wealthy, but this agreement proves that we married for love, not money, because he was not claiming any of her wealth. Until that case, really, there was a general public policy reason for not upholding prenups, because some people thought that it would encourage divorce, because you're setting yourself up for a divorce in the end. But actually, after Radmacher and Granantino, the court says no, nuptial agreements, pre and post nups, need to be treated as the same, viewed as the same. These are autonomous adults going into an agreement. They're signing up and they're intending to create legal relations. We have to respect that autonomy. We have to respect that people are able to make their own decisions.
See, I think that's
sign up to an agreement.
I think that's what you've just said there. I think it's wonderful to be able to say, if we're marrying for love and not money, then why should signing a prenuptial agreement be such a problem and be unromantic? I like that.
Well, that's what Ms. Radmacher said in her case. Now, what you have to be careful of, though, is that they are not simply upheld by the court. The court has overall jurisdiction in a case, in a financial settlement. The court has regard to Section 25 of the Matrimonial Causes Act, and there are certain criteria within there that are factored in. A prenup could be determinative, but there are certain factors of a prenup that must be included. Now, I talked about a review clause. That's not absolutely key, although it is useful because it makes the prenup more up to date, or the postnup, as it would be more up to date and therefore more relevant as you move through your marriage. And it may just be reaffirming what's in there. But if you go into an agreement and it's not fair, if you sign up to an agreement and it just says one party gets absolutely everything and there's nothing there for the other person, that's not a fair agreement. It's not meeting both parties' needs. And although Radmacher upheld the agreement in that case, this is, as I say, over 10 years ago, they made sure that the husband was able to have a home for himself and the children. And at the Court of Appeal, and then confirmed by the Supreme Court, they said that the housing need was whilst he was parenting the children. So actually, only until, well, I say only, but until the youngest child is 22, actually in a few years' time, they will have, he will be able to keep the property that he was given, but he then has to give that back because it is it is his needs as a father, and it was giving him enough time to be able to stand on his own 2 feet. Okay, that's I'm putting it in
because that's what I mean. This is quite interesting because when we talk about ring fencing assets, so if, for example, the other party is coming into the marriage, and I'm going to keep this really simple, one of you own a property, the other one doesn't. You come into the marriage, you get married, you rent somewhere. So, for some reason you're renting maybe a bigger place, maybe in another area, and then you're going through a divorce. Are we saying that you can't ring fence the one asset that you have because it's not fair that the other party will not be housed? I mean, they can go and rent. What's happened to the rental market?
No, it's a really tricky one. Now, you both have to have the benefit of independent legal advice, so Absolutely. No joint legal advice. And that may be that the financially wealthier party has to pay for the other advice, but they definitely shouldn't choose the solicitor or a barrister who they go to.
Yes.
It has to be independent, and there shouldn't be any undue pressure on the other side. And you certainly shouldn't prejudice the needs of any children within the agreement. All of those things will really chip away at the agreement, and it could make it arguable and potentially subject to litigation between you.
I just want to be clear on that one point that you said there, Nicola, because I think it's really important. When we're saying that the other party should take legal advice, even if you have to go and pay for them to take the legal advice, the reason why we say don't go and select the solicitor for them, because I've heard this so often where we have a client that says, actually, I've told them where to go to get the advice because that solicitor is a good solicitor and I know them. That doesn't work because it's a conflict of interests. That person can argue, well, I took advice from somebody where my husband, who's drawn up the prenup agreement, or my wife who's drawn up the prenup agreement, has got very close relations, and that advice was tarnished. It was biased to my partner, and that's why we say make sure it really is independent legal advice where they've sourced their own legal assistance without pressure, because that's another thing. I've seen an argument where someone says, I had to get legal advice. I was not given enough time to go and get the level of advice that I wanted, and I just made do with the first bit of information that was thrown at me, the first advisor that was available, and therefore I didn't have the opportunity to really seek advice in the time span that I was saying. And what you're saying is absolutely right, isn't it? You've got all those things can chip away at how strong your prenup or postnup will be.
Absolutely.
When it's time to look at it.
In fact, there's a case in the recent years. The name escapes me right now, but I remember that there was an heiress in America. They'd signed up to a prenup, but she had recommended a lawyer, and they weren't even a family lawyer, and they didn't have any expertise in the law of the jurisdiction that they were wanting to rely on for the prenup. So actually that was one element. It wasn't the only reason that prenup didn't stand up in court. But Hatti, one thing that to note as well is that although Radmacher is the Supreme Court decision, the Court of Appeals decisions in recent years, they tend to say we're going to meet needs, of the party, and any prenup that they might say it's nearly fair, but if the needs of the party aren't met at the time of separation, then they might just give a little bit more over and above what the prenup suggested, and that's why I say about the review clauses, I think they're very useful, because you can say at the time the closer you are to the separation, you can say, well, look, the circumstances haven't changed that much. We've said the needs for a house are, say, 300,000 for a house in this area, and if you index link that house price, you can limit those needs to an extent. And I think whatever reasons people have for going into prenups, yes, it might be about money, but the key thing, I think, for a lot of people that I work with is, let's try and limit any litigation. Let's try not to have a really, really emotionally draining process that is divorce and court. Let's try and limit that between us.
And costs. And costs as well. I mean, the financial implications of financial divorce are huge, but I mean, that's all we've got time for. But what I will say, and then absolutely you can add your wrap up bits here, Nicola, is just don't try and do these sorts of things yourself. There are online, download a prenup agreement template and all of that. Honestly, if you're going to go down that road of saying, I want a proper prenup that is fair, reasonable, and is able to ring fence any assets that I've, I just think it's fair and reasonable to do so, and my partner agrees with that. Get it done properly. The example I give to people that come along and talk about legal advice in my law firm is, I'm not a car mechanic, so I wouldn't try and service my car. I wouldn't say, well, actually, I can Google that bit and get it done. I take my car to a mechanic who does it. So don't try and do these things yourself. It's great to be in the knowledge. I think that more, prenups have got really, in the public domain, I think, a really unfair and probably untrue thought process to them. People think, oh, they're not worth it, or they never stand up in court and things like that. But when you've got this sort of information that we're talking about today, you can actually, it could be a little bit easier to sit there and say, do I want a prenup? And you made it clear at the very beginning, you don't have to have a prenuptial agreement prior to marriage to have a post-nuptial agreement. It could be that you're years into a relationship, you've clearly done a lot more, or you want to try and ring fence something special or inheritance in some way, and get professional legal advice and get it done properly.
Yes, and in terms of the post-nup, they do exist standalone, but commonly they are reinforcing what's already in a prenup. Obviously, there are lots of pressures on people and what have you coming up to marriage, but that's the general time that people will do a prenup and then put it into a post-nup afterwards. Hatti, I know this is a huge topic, and we've tried to cover as much as we can.
There will be a part 2, Nicola, and a part 3 and a part 4. Make no mistake.
Well, let me say, I know I'm writing a book on prenups and postnups as we speak.
What is it called? When is it out? Where are we with that, Nicola?
So that is a practical guide to prenuptial and postnuptial agreements, which I'm currently writing, and I hope to finish very, very soon. But it will cover everything, and there's so much in this topic. It's hard to have covered everything. So yes, get your legal advice is what I would say. It's not a simple one-line agreement usually, because you can't demonstrate to the court that you have considered everything. The more information you have in that agreement, the more about the background circumstances, why you're doing it, that you intend to create legal relations, it's more likely that when the court is doing its discretionary exercise under Part 25, they will say, yes, this is an agreement that is fair, and this is an agreement we can uphold, and let's hold the parties to that agreement.
Good. Nicola, thank you ever so much. I certainly hope that by the time we do part 2, you'll be saying, I've finished my book. Here it is. This is where you can pick up a copy. And I think it's fantastic that you're writing a book on it. And I certainly look forward to having a little read myself. But thank you very much for your time today.
Thank you, Hattie. Thanks very much.
I'll say to our listeners, don't forget to click and subscribe to our podcasts, and you can find us on Instagram, Twitter, Facebook, LinkedIn and YouTube by searching Get Legally Speaking. Also visit our website at getlegallyspeaking.com. Thank you very much for listening.